Good morning and welcome to the Supreme Court of the United Kingdom. This is a hearing of an appeal in relation to a commercial dispute between two Chinese companies. It concerns the chartering of a vessel and a guarantee of the liabilities under the charter party, and it involves allegations of bribery and torture. The appeal is brought by Shagang Shipping Company Limited in liquidation, and the respondent is HNA Group Company Limited. There is also an intervention by an NGO, Liberty. Today, the appellants are represented by Lord Panic QC, assisted by Carolyn Pounds and Tom Richards. The respondents are represented by Edward Brown, assisted by Jessica Boyd and Isabel Buchanan. And the intervener is represented by Ben Jaffe QC, assisted by George Molyneux and Natasha Simonson. I will introduce each of the justices who is sitting on the appeal and then invite Lord Panic to make his submissions. I am Lord Hodge. Lord Briggs?
Good morning.
Lord Hamlin?
Good morning.
Lord Leggett?
Good morning.
Lord Burrows?
Good morning.
Lord Panic, I invite you to make your submissions.
Thank you very much, my lord, and good morning to the court. Shagang disagrees with much of the Court of Appeal's judgment, but there's no dispute about what the Court of Appeal said at paragraph 1 of its judgment, MS 192. I quote, "This was an unusual case," and your lordship has summarised the context, an allegation of bribery, counter allegations of torture. The trial judge, Mr. Justice Knowles, had a difficult task, and he had a difficult task because, as he pointed out at paragraphs 83 to 85 of his judgment, it's MS 224, the evidence that he had was very limited in crucial respects. He noted at paragraph 10 of his judgment, MS 213, that none of the primary individuals who were involved in the alleged bribe gave evidence to him. He also noted at paragraph 13 of his judgment, it's MS 213, that the documentation available was, quote, substantially incomplete. What Mr. Justice Knowles did was to reject the allegation of bribery for reasons to which I will come. The Court of Appeal concluded that his lordship's judgment could not stand because the judge should first have decided whether there was torture. That's paragraph 61 to 63 of the Court of Appeal judgment, MS 202. The Court of Appeal said that his conclusion amounted to a finding of no torture. That's paragraphs 60, 77 and 91. And the Court of Appeal criticised the judge because they said he had not properly assessed the admissions that were made in the Chinese criminal proceedings. That's paragraph 77 to 78 of the Court of Appeal. And as this court knows, the Court of Appeal remitted the case to another judge for a retrial, but on the basis that the allegation of torture had already been rejected and so could not be considered by the new judge. That's paragraphs 88 and 91 to 92. The competing written cases, which the court will have seen, have clarified that the following are the main issues before this court. The first issue is whether or not the criticisms made by the Court of Appeal of the reasoning of the trial judge on whether there was a bribe were justified. And we say that the Court of Appeal's criticisms were wrong for two main reasons. The first, we say, is that the Court of Appeal were wrong to find that the judge had concluded that there was no torture. We also say, still under the first issue, we also say that the Court of Appeal was wrong in its criticisms of the judge because he did not, said the Court of Appeal, make more detailed findings on the admissions before reaching his conclusions on whether there was a bribe. HNA say that this latter point, that is the criticism of the Court of Appeal's reasoning, is not covered by the grounds of appeal. And I will deal with that objection in a few moments. That's the first main issue on the appeal. The second main issue on this appeal arises if the court is against us on issue 1. And if the court is against us on issue 1, the case will be remitted for a further hearing. I should mention that the Court of Appeal did not find that it could decide the factual question of whether there was a bribe in this case, and so avoid a rehearing. And HNA are not asking this court to do more than remit the case for a further hearing. But on this second issue, if the criticisms made by the Court of Appeal are justified, and therefore if the Court of Appeal was right to remit the case to another judge, the second main issue on this appeal is whether the Court of Appeal was wrong, as we submit, to conclude that the new judge should consider whether there was a bribe on the basis that there was no torture leading up to the admissions. We say it would be for the new trial judge to consider whether there was torture, in which case the admissions cannot be relied upon, they're excluded as evidence, or if the judge cannot so conclude, the new judge must take account of the risk that there was torture in deciding what weight to give to the admissions, hearsay evidence. We say that the weight to be given to the admissions is not a binary question. It's to be decided in all the circumstances, and in particular, in the light of the risk that the admissions were the consequence of torture. My Lords, there was a third issue concerning the application of the concept of bribery in this context, and it would have raised interesting questions. But that is no longer pursued by us in the light of the observations made in HNA's written case that any questions of law arising under this issue can and should be addressed at the retrial on the basis of the facts found. And we see great force in that. And there's been correspondence on this issue, which is before the court, and which I'll come to briefly in due course. So that's our understanding of the agenda, the issues before the court. May I deal first then with the first issue, that is the basis on which the Court of Appeal allowed the appeal and remitted the case to be heard by another judge. And could I invite the court to go to Mr. Justice Knowles' judgment, which can be found in the core volume. It starts at MS 210, And can I identify the central paragraphs in that judgment on this issue, bribe or no bribe? The court will see at MS 224 at paragraph 87, the judge says, on the limited evidence at this trial, after careful consideration on the balance of probabilities, I find there was no bribe by Mr. Zui, one of the employees of Shagang. That's the finding that the judge reaches. There's then some reasoning, which of course I will come back to. And then if we turn please to MS 226, there's a heading, Conclusions on Torture. And the first conclusion at 101 in the final sentence is the judge finds that torture cannot be ruled out as a reason for the confessions. At 102, his lordship says that the fact he cannot rule out torture further reduces the confidence that he can put in the confessions. And then this, although it will be apparent from my conclusions on bribery above that I already have insufficient confidence in the confessions to allow a finding of bribery. So he's there repeating that his finding is no bribery, whether or not there was torture. And at 104, he repeats the point, in the present case, in the circumstances of my conclusion that there was no bribe, it is not necessary to express a definitive conclusion on whether there was torture. I have said I cannot rule it out. The evidence available does not equip me well to reach a firmer conclusion. And he adds a further reason at 105. Now, the Court of Appeal's first criticism of this judgment is that the judge should have decided the torture issue first. And your lordships see that in the Court of Appeal judgment at MS 202 to 203, and it's at paragraphs 60 through to 63. And at MS 202, in the right-hand column, your lordships will find paragraph 60, and about a third of the way down that column, in paragraph 60, the court will see there's a sentence. In the present case, the judge was unable to find on the balance of probabilities that the admissions had been obtained by torture. That was in law a finding that there was no torture. So that's the starting point. At 61, the Court of Appeal described the submissions for HNA. Mr. Smuhar's fundamental criticisms of the judgment were that he, the judge, had not decided the primary torture issue first, and that he'd not properly applied his decision on that issue to his evaluation of the reliability of the admissions. Had he approached the matter in the right order, he would have concluded that torture was not proved on the balance of probabilities. On that basis, the challenge to the admissibility of the admissions was defeated, and the judge should have given them effect in deciding whether there was bribery. Then there's a bit more detail, and I can skip, I'm sure the court read all of this, I can skip to paragraph 63, which is the conclusion on this point. In our view, the judge ought to have decided the issue of torture first. It was the sole basis on which the admissibility of the admissions was resisted. All the other arguments went only to the weight that should be accorded to them. The judge's first task was to decide on the facts whether or not torture had taken place in order to extract each of the three main admissions relied on. Once he'd done that exercise, the judge should have stated his conclusion that since torture had not been proved, the admissions were admissible as evidence of their contents. The Court of Appeal returned to the same point at paragraph 77. At the beginning of that paragraph, it's on MS 205. They say, in any case, the judge's treatment of the weight to be given to the admissions was inadequate. He didn't address the point at all. He omitted the step. Once he'd found that the admissions had not been obtained by torture, if he was going to reject them as unreliable, he needed, in our judgment, to say why he was doing so. One other preliminary point before I make my submissions on that reasoning. If the court goes back in the judgment to MS 192, the court will see that at paragraph 3 of the judgment, MS 192, paragraph 3, the Court of Appeal states, quote, "It was common ground that this approach," that is the judge's approach, meant that the judge had in fact determined that the admissions had not been procured by torture. My lords, that most certainly was not common ground in the Court of Appeal. Our skeleton argument did not so suggest. And when the point was put to Shagang's counsel, Miss Dinah Rose, Queen's Counsel, in the course of argument, she, with her customary force and clarity, made clear that these matters were not agreed. Can I ask the court to turn up additional volume number 1 at MS 409, which is part of the transcript in the Court of Appeal. And at MS 409, in the right-hand side of the page, right-hand column, your lordships will see at line 6, Lord Justice Voss intervenes, and at line 13, his lordship puts to Miss Rose, I mean, if you didn't have to decide whether there was torture, that's a different point, but you are agreed that he did have to decide, and he did decide there was not torture. Miss Rose, no, my lord, we are not agreed, we are not agreed. The court can no doubt hear Miss Rose saying that in your lordship's head. So that was our position. The point arose again on the next page, MS 410, another extract. This is the second day of the Court of Appeal hearing. And on the left-hand column, line 5, Lord Justice Voss puts to Miss Rose, you accept he, that's the judge, is not making a finding, is no finding of thee. And Miss Rose interjects, my lord, I accept there is no finding, but what I don't accept is that that equates to a rejection of the evidence. It specifically is not a rejection of the evidence. Let's look. And Miss Rose then refers to what I've shown the court a few moments ago, what the judge said at paragraph 101 and what he said at paragraph 104. So can I turn to the substance of this point? We say that it is very clear indeed that the approach adopted by Mr. Justice Knowles was that he did not need to decide the question of torture because his lordship was in any event satisfied that there was no bribe. See paragraph 101, MS 226. I find that torture cannot be ruled out as a reason for the confessions. Paragraph 102, he had for other reasons decided there was no bribe. And 104 and 105, which I've shown the court. If it matters, we also have what the judge said when he refused HNA permission to appeal to the Court of Appeal. We have that at MS 247. This is the judge's written document refusing permission to appeal at MS 247, and the reasons begin halfway down the page. And in the second paragraph, beginning, if I do have jurisdiction to deal with permission to appeal, I refuse permission because, and then leaving out a few words. In the third line, I do not consider the defendant's proposed arguments that a different conclusion was compelled by the fact that individuals had at times said there was bribery are sound arguments. This is essentially for the reasons given in the judgment. Although I considered it important to address the torture allegations in my judgment, I believe I made clear that my conclusion on alleged bribery did not depend on my conclusion on alleged torture. And he refers to the relevant paragraphs. Of course, it is common for judges not to make findings on particular issues that have been raised in a case where they take the view that it is unnecessary for the disposal of the case. Lord Justice Davis understood and accepted this point when he too refused HNA leave to appeal in the Court of Appeal. And this court will see what Lord Justice Davis said at MS 251. It starts this document at MS 248. This is the refusal of permission to appeal. And the relevant passage is at MS 251, and it's at paragraph 8 of Lord Justice Davis's determination, where his lordship says, in such circumstances, there was no further requirement for the judge to make an express finding on whether or not there was also torture. He clearly had doubts on the matter, but he in turn stated it was not necessary to reach a conclusion. He made clear that his other findings were sufficient to justify his conclusion that he could not attach weight to the purported confessions. See the paragraphs I've shown the court. It is, in my view, says Lord Justice Davis, wholly wrong to argue that just because the judge made no finding of torture, therefore the confessions must be taken as true. So we say there is no basis for inferring that the judge was finding that the admissions were not caused by torture. With the greatest of respect, the Court of Appeal ignored what the judge actually said. I still have to deal, of course, with the other criticisms of his lordship's judgment, but we do say, this is our case, once one strips away the erroneous finding by the Court of Appeal that this judge had found no torture, the complaints about the judgment made by HNA are in truth a complaint about the weight which the judge gave to the admissions evidence. And that is a matter for the judge, not for an appellate court. So can I turn then to the second part of this first issue? That is the criticism made by the Court of Appeal that in light of the fact that the judge had found no torture, he, the judge, had not properly assessed the admissions made in the criminal proceedings in China. And the Court of Appeal's criticisms can be found at MS 205, paragraphs 77 and 78. MS 205, paragraph 77, I've already read the opening sentences of paragraph 77, and his lordship, the Court of Appeal then adds some detail, but it's 78 where they come to their conclusions. At 78, they say, in our judgment, the judge's approach in the section of his judgment entitled Conclusions on Bribery was inadequate to answer the two necessary evidential questions. What weight should be attached to each of the admissions relied upon by HNA? And was a bribe paid by Mr. Zhu to Mr. G.T.? The judge never addressed the first directly. He took into account an irrelevant factor, naming the testing of the officer's evidence, and he never reached any conclusion on the relevance of the leniency that was offered. Then there's a bit more detail, and then they say he did not say whether or not he thought, in the light of each of the relevant individuals, that the prospect of leniency was a reason why the admissions in question were false. Then they say, and I'll deal with this, it's to be noted, while one can quite understand how an offer of leniency might bring forth a truthful confession that might not otherwise be made, it is somewhat harder to see why a suspect would make up something wholly untrue in order to get a lenient rather than a harsher sentence. And I'll have some observations on that part of the reasoning. Now, there's a preliminary issue on this point, because HNA have objected, as the court knows, in their written case to whether these criticisms that we're making, in particular paragraph 78, fall within the scope of the grounds of appeal in this case. We, I confess, were taken by surprise by what was said by HNA in their written case, because if the court would look at the agreed statement of facts and issues and look at the agreed issues in this case, it's MS 69, document begins at MS 58, but it's MS 69 where the issues are set out. At paragraph 48, the parties agreed that the issues arising on this appeal are as follows, and they included: one, whether or not there exists any basis in law for the Court of Appeal interfering with the judge's conclusions in light of the facts found by the judge, which are not in themselves challenged by either party. Item 3, whether or not the judge failed adequately to analyse the proper weight to be given to the admissions. And item 6, whether the Court of Appeal was correct in identifying a combination of flaws in the judge's reasoning, and if so, whether that renders the judge's decision unsustainable, or whether, as we submit, the judge was entitled to find as he did on the basis of the evidence before him. So those were the issues agreed a year ago, agreed without difficulty, without qualification by HNA. The points we are raising fall undoubtedly within the scope of those issues. It is, as I think HNA accept, quite impossible to see how there could be any prejudice to them in us arguing the points that I want to argue, given that they've had a year's notice that it's an issue, and given that we set out our case on this point in our written case, and they've answered it as a matter of substance in their written case. If necessary, we apply to amend our grounds of appeal. I suggest, and I know that HNA agree, that the most convenient way to... I'm sorry, my lord has a question.
I just wanted to ask, Lord Bennett, would I be right to understand there'd be no point bringing the appeal at all if you can't argue this point, because you'd be bound to lose? And we might as well go home now.
That no doubt would be quite tempting. The answer to the question is no. I explain why, because if we can't argue this point, there's still issue number 2. The case is to be remitted.
I see. So even though you lose in setting aside the Court of Appeal's direction to remit it, there's still an argument about the scope of the remission.
Yes, precisely so, my lord.
Yeah.
This only goes to whether there should be a remission. Our first argument is the Court of Appeal was quite wrong to overturn the trial judge's judgment. But it's an important point. The court has given permission to appeal. It would be unrealistic, in my respectful submission, to consider this appeal and not consider the substance of the criticisms that the Court of Appeal made of the trial judge. And indeed, the points we're raising are to some extent intermingled with the points we want to raise on issue 2. What happens when the case goes back to another trial judge? So we've set out further arguments, in particular in the correspondence that followed from the objection that was made by my friends. I hope the court also has a supplementary MS bundle, and if the court wishes to do so, the court will see that we've set out our arguments on why we should be given permission to amend the grounds if we need to at MS supplementary MS pages 3 and 4, paragraphs 1 to 6. And for good measure, we've also filed an application form seeking permission to amend the grounds, which starts at MS page number 9. All of that, we say, is completely unnecessary, but it's there if the court needs it. We would therefore ask the court to hear us, as I think my friend accepts. The court should do de bene esse, and the court can hear the objection in due course if so advised.
That is how we'll proceed, Lord Panic.
Thank you very much. Can I then turn to the merits of this complaint? And could we go back, please, to the trial judge's judgment, beginning at MS 210, and take the court back to the judge's conclusions on bribery, which were at MS 224. And I've already read paragraph 87, where the judge states his conclusion. He then sets out at paragraphs 88 through to 100 why he has reached that conclusion. And he sets out a number of factual findings, none of which are challenged or were challenged by HNA in the Court of Appeal. And indeed, they're not challenged in this court. See the Court of Appeal paragraph 53, that's MS 201. See paragraph 54 of HNA's written case, MS 142. So what factual findings did the judge make that led the judge to the conclusion that he reached? That is, there was no bribe, irrespective of torture. The first main finding is at paragraph 91 on MS 224. And the judge said this: the reason given for the alleged bribing, that is, concluding the charter party quickly rather than the pricing of the charter party, is unconvincing in my judgment. Even if there was a desire for a quick conclusion, I am unpersuaded on the evidence that bribes were introduced to achieve that end. At one point, Mr. Zhu suggested it as a reason for bribing. Same appears to be the case for Mr. Shen, but both have denied any such bribe. And then this: further, the state of the market was not such as to provide an objective reason for a quick conclusion being so important or being other than achievable in ordinary course in any event. The relevant chartering market was active and an owner's market. As for the facts that the charter period would commence in 2010 and be of some length, it's hard to accept these would have made a difference. Shagang itself had recently agreed a charter party for the vessel of identical commencement and duration to the charter party. Now, there's no appeal, never has been an appeal against any of those findings, and they're backed up by what the judge found at MS 214 at paragraphs 18 and 19. That's the factual findings that support what the judge concluded at paragraph 91. The second important factor that influenced the judge when he decided there was no bribe are the factors set out at paragraph 92. And at 92, he says, even when Mr. Jia gave an account consistent with receiving a bribe, that account supported the fact that Mr. Jia's response was to insist on normal procedures. Mr. Jia...
Lord Panic, I think Lord Hamlin would like to interject.
Yes, I'm sorry. Thank you.
Lord Panic, just going back to the commercial context, the 300,000 renminbi in 2008 would have been how much? About $45,000?
About that, yes, I think so.
And what was the difference between the charter rates under the head charter and under the charter with Grand China?
That I'm going to have to find out, my lord. I don't know the answer to that. I will find out.
Around $8,000, my lord.
Sorry?
Around $8,000 per day.
Right, per day. Okay, thanks.
I'm grateful to my friend. Then 92, paragraph 92 is the second reason that the judge gives. I was referring to the first sentence. The second sentence: I do not overlook HNA's point that a requirement for board approval was lifted and the charter party was not submitted for a required legal and financial review, but in the result, the charter party was approved by, among others, a main board director of HNA and by the chairman of HNA. I do not overlook Mr. Wu's evidence. He did not become aware of the charter party until 2011. He was the general manager of audit and legal affairs at HNA. But in the next several years, following the agreement of the charter party in 2008, I do not see anyone at HNA bringing out the point that the charter party was agreed too quickly so as to cause suspicion of bribery. So that's his second reason. Again, all of those facts are undisputed. Paragraph 93 is the third reason for the judge's conclusion. The judge points out that he's seen no records, no documents showing any withdrawal of funds used for the alleged bribery or expenditure of funds by Mr. Jia. This was, of course, despite the fact that there had been a criminal investigation in China by the Public Security Bureau. Again, there's no challenge by HNA to those facts. So those were the substantial reasons why the judge felt able to conclude on the evidence that he had heard that torture or no torture, this was not a case where he was satisfied that there had been a bribe. Bribery made no sense in the commercial context. The charter party went through normal procedures, or substantially normal procedures. No one had complained about it for a long time, and there were no documents to support bribery. Now, our case is that the judge had regard to all the evidence before him. He reached a conclusion for those reasons that was open to him. It is true that the judgment was a short one, but it covered all necessary points. And as many authorities establish, the judge who has had the advantage, not open to the appeal court, of hearing all the evidence and arguments, is not obliged to set it all out in detail. We say that this is a paradigm case, a paradigm example of an appeal court, with great respect, impermissibly interfering without recognising that the judgment is a necessarily incomplete statement of all that the judge has heard. And I do not need to remind this court, and I won't remind this court, of all the authorities that establish repeatedly that authorities in this court and in its predecessor, the appellate committee, that it's not for an appellate court to, with respect, pick over the judge's findings on the basis that they could have been better or more fully expressed. I recognise that this does not prevent, these authorities do not prevent the appellate court from intervening if the trial judge's reasoning is defective. And my friends have relied on an authority to that effect, Data Electronics, which no doubt they will deploy. And I accept the principle. But I submit, an appellate court should be very careful indeed not to allow a disappointed party to dress up as a challenge to reasoning what is in truth a complaint about unappealable findings of fact. So what happened here? This trial judge did not ignore the fact that the admissions had been made in the Chinese investigation and in the Chinese criminal proceedings. The judge referred to that at paragraph 88, which is on MS 224. And the judge said that he fully acknowledged that the Chinese court had found Mr. Zhu guilty of bribery and had sentenced him. And the judge said on the material put before that court, he, the judge, could entirely follow its reasoning. However, material has been put before this court that was not put before the People's Court. In particular, the People's Court had evidence of Mr. Zhu and others admitting the alleged bribe, but they didn't have the evidence of his and their also denying the alleged bribery. And of course, what they didn't have was the contextual factors, particularly those that the judge refers to at 91 and 92. The judge then refers at 89 to the fact that when the admissions were first made, they were made without a lawyer or representative present. And the Court of Appeal accepted at paragraph 71 of its judgment, it's MS 204, the Court of Appeal accepted that the absence of legal representation at that stage was a relevant factor in considering the weight to be attached to the admissions. Then there's paragraph 90, which the Court of Appeal criticised. And can I come back to that? Because it was a criticism that the Court of Appeal itself said was not crucial. And I'll come back to it and deal with it separately if I may. And my friends accept that paragraph 90, that criticism is not crucial. I've already referred and read out 91 to 93, which sets out the reasons why the judge concluded that he was not satisfied there was a bribe. At 94, he says this: the reasons I have given would alone cause me to reach the conclusion that there was no bribe. I am not led to a different conclusion by the fact that Mr. Wu pleaded guilty at trial when I consider that plea in context. And then he deals with another matter that's accepted to be irrelevant. Now, I submit that there was no justification in these circumstances for the criticisms made by the Court of Appeal. As I've already submitted, the Court of Appeal was wrong to conclude that the judge had found no torture. And I've also submitted that the judge was entitled to say, I'm not satisfied there was a bribe, whether or not there was torture in this case. At paragraph 97, the judge turns to a point made by HNA, which is why should your employees have made admissions unless there was a bribe, at 90, or unless there was torture. 97, HNA argues that in the absence of torture, there is no credible reason why Mr. Zhu, Mr. Jiati, and Mr. Shen should falsely confess to crimes which they did not commit. However, says the judge, the possibility of a large difference between the sentence that might follow an admission and the sentence that might follow a conviction was referenced expressly by Mr. Zhu in his exchanges with his lawyer, Mr. Guo, and on his account reflected what had been indicated to him by officers in the PSB. The judge had referred to this earlier in his judgment at paragraph 38, which is on MS 217. The second sentence of paragraph 38 on MS 217, Mr. Zhu explained a decision to adhere to his earlier account accepting guilt because it would lead to a much reduced sentence than if he contested the allegations and was found guilty. There's sufficient material to show that according to Mr. Zhu, this reflected what had been indicated to him by officers of the PSB, and the agreed statement of facts and issues sets out the suggestions of leniency that were repeatedly made. If the court would go to the statement of facts and issues, MS 64, paragraphs 29 and 31 refer to Mr. Zhu's statements that he was influenced by leniency. Paragraph 19, at the end of it, quotes Mr. Zhu as saying he'd subsequently confessed the full extent of his crimes for leniency. and there's also considerable material showing that all three of those who had made confessions were told by the officers of the PSB that if they did admit to bribery, this would lead to a lenient sentence. We've set out all the references, and I won't take the court through them unless invited to do so, of course. In our written case, MS 81, paragraphs 9, 10, and 11. Paragraph 9 deals with Mr. Zhu. Mr. Giati is at paragraph 10, Mr. Shen, paragraph 11. There's a mass of material showing that all of those who were questioned or interrogated, as we would put it, were told leniency would work very much in their favour. The judge also had expert evidence which showed that 95% of suspects in China confess to the criminal offences with which they are charged. 95%, and also that it is very rare indeed for a Chinese criminal court to acquit a defendant. We've summarised that expert evidence at in our written case, MS 84 to 85. It's paragraphs 13 subparagraph 4 and 13 subparagraph 5. The judge, in his judgment, commented on this expert evidence. He commented at paragraph 16 of his judgment, MS 214, where he said, paragraph 16, MS 214, I have found the expert evidence valuable. And then he said there were two important limitations. It's limited to context or background, and he would have benefited from more materials and information. The judge also referred to the expert evidence at MS 222. This is paragraph 70 of his judgment. The expert evidence shows, his lordship said, that a high proportion of criminal convictions in China follow confessions from the accused. I'm not asking this court to make findings, of course. It is theoretically possible that the Chinese criminal justice system is exceptionally efficient in prosecuting only those, or almost only those, who are guilty of the crime alleged. A more realistic conclusion, which was that of the judge at paragraph 97, which I've read of the judgment, MS 225, is that there are many, many cases in which innocent persons plead guilty because they hope for a lenient sentence and because they know their chances of acquittal are very low. Now, the Court of Appeal had two criticisms of the judge's reasoning in this respect. The first criticism I read to the court at paragraph 78 at MS 205 in the right-hand column. And it bears repeating again because it is so striking. MS 205, about 15 lines down, the Court of Appeal says it is to be noted that whilst one can quite understand how an offer of leniency might bring forth a truthful confession that might otherwise not be made, it's somewhat harder to see why a suspect would make up something wholly untrue in order to get a lenient rather than a harsher sentence. That, in my submission, is a quite startling statement, even in the very different context of the English criminal justice system. The strengthening of protection for those suspected of criminal offences in recent decades has been prompted, there's no controversy about this, it's been prompted by the painful experience that for a variety of reasons, individuals have confessed to crimes of which they were wholly innocent. We've given, and I don't want to take time on this, but we've given two infamous examples in paragraph 42 subparagraph 3 of our written case, MS 99, the Queen against Judith Ward, where the defendant confessed to involvement in bombings, and the prosecution case was largely based on her confessions. The Court of Appeal allowed the appeal. And of course, the Birmingham 6 case, Queen and McElkenny, to like effect. So I do say, I have to say, with enormous respect, that that part of paragraph 78 of the Court of Appeal judgment is surprisingly naive. It is perfectly understandable that someone faced by a false allegation, which they believe will almost inevitably result in their conviction, will admit wrongdoing in order to minimize the sentence, and especially so in a legal system such as the PRC, which lacks basic legal safeguards such as the PRC system. One doesn't, I think, need to go into that. So that part of the criticism, I say, is wholly unfounded criticism of the paragraph 97 of the trial judge's judgment. The other criticism made in paragraph 78 on MS 205 is that the trial judge did not make a finding, and one sees this at MS 205 in the right-hand column, about 12 lines down. He, that's the trial judge, did not, however, say whether or not he thought, in the case of each of the relevant individuals, that the prospect of leniency was a reason why the admissions in question were false. I say that the judge was not obliged to make any such finding of fact. What the judge was responding to, and one sees this again at MS 225 paragraph 97, was the criticism, well, not the criticism, was the point made by HNA, see paragraph 97, that in the absence of torture, there is no credible reason why they should make a confession to crimes which they did not commit. And the judge's reasoning at 97 is directed to that point. There's a very credible reason why they may well have confessed, albeit they did not commit the crime of bribery. But there's a second answer to the judge's point, and this overlaps with what I am coming to on the second issue on this appeal. And what I'm going to submit on the second issue in this appeal is that the evaluation of a hearsay statement, because the admissions, of course, are hearsay statements, does not require binary proof of each factor that goes to the weight of the evidence. What the judge was saying was that there was a perfectly credible reason why they may have confessed in the context of the criminal proceedings in China, even though they were innocent, and that in the circumstances of this case, the admissions may well have been made out of a desire for leniency, and that this was a factor which the judge was entitled to and did take into account when weighing up the admissions evidence. And that's how the judge proceeded. In my submission, he was perfectly entitled to say, I've made the factual findings, none of which are in dispute, at 91, 92 and 93, and I'm not persuaded to the contrary by the fact that these men made admissions for all the reasons that he gave. And that was a judgment open to the judge on all the evidence before him. One further paragraph I said I was going to come back to, paragraph 90 of his lordship's judgment at MS 224, where his lordship said there is no evidence that any account of the officers of PSB who were present at any interrogation has been tested with them in China. I appreciate the practical difficulties, but there has been no opportunity to test an account from them at this trial. And the Court of Appeal was critical of the comments in that paragraph at paragraph 70 of the Court of Appeal judgment. And if the court goes back to the Court of Appeal judgment, paragraph 70 is on MS 204. And in paragraph 70, the Court of Appeal say it's worth noting the judge's finding that the officer's account had not been tested was reached in ignorance of the new evidence, which tended to show their accounts were tested in the PRC. And I'll come in a moment to the new evidence. But that doesn't really matter, since HNA's challenge simply contends that the judge's reference to the officer's account could only have been relevant to the torture question and not to the issue whether bribery actually occurred. We agree with that challenge. Now, the parties agree, because the Court of Appeal said that this is not a crucial point. The Court of Appeal said that at paragraph 72 of its judgment, still on MS 204. In conclusion on this point, therefore, it does seem to us the judge was to some limited extent influenced by questions that related to the torture issue in considering the bribery issue. That error by itself might, however, not be sufficient to require us to allow the appeal. The crucial issue is the next one, namely the judge's evaluation of the evidence relating to bribery. And that's what I've already addressed. So the Court of Appeal did not regard any error in paragraph 90 of the trial judge's judgment as critical, and that's recognised by my friends for HNA in their written case. I won't ask the court to turn it up, but it's their written case, MS 122, at paragraphs 20, subparagraph C, and 79. One further point, if I may, on this first issue before this court. HNA have now relied in their written case, and it's paragraphs 5 and 65, on the fact that the Court of Appeal allowed HNA's application to admit fresh evidence. And HNA therefore submits that even if the judge's reasoning were to be upheld, the case still needs to be remitted so that this fresh evidence can be considered. The Court of Appeal summarised what this fresh evidence is in the judgment. If the court can turn, please, to, first of all, paragraph 23 of the Court of Appeal judgment, which is at MS 194. The judgment at MS 194, paragraph 23, notes that in 2014, the Procuratorate made a report on the outcome of its investigation into the complaints. That was the complaint of torture. It's unclear to whom the report was sent. It concluded that none of the allegations made in the complaint were supported by the facts. The officers had visited the PSB, they'd interviewed the suspects, they'd retrieved from the detention centre relevant materials. Neither the complaint nor the investigation report was available to the judge, but HNA's application to adduce them as new evidence on the appeal was ultimately not opposed by Shagang, and Shagang conceded that the complaint ought to have been disclosed, but denied having seen the investigation report at the time. And then at paragraph 47, which is at MS 199, in the left-hand column, 2/3 of the way down under the heading HNA's application to adduce new evidence, 47, as we have said, HNA's application to admit the documents relating to investigations into the torture allegations was ultimately not opposed. And then there's a description of what the documents were. And at 49, there's a description of why the documents were said to be relevant. That's HNA's submission. Now, we make 2 points on this argument that the case has, even if we're correct in the criticisms we've made of the Court of Appeal, in any event, the case needs to be remitted back to the High Court. First of all, the Court of Appeal itself did not suggest that this fresh evidence meant that the appeal had to be allowed and the case remitted. On the contrary, the reasoning of the Court of Appeal was based exclusively on what it found to be the defects in the reasoning of the trial judge. And I've addressed those points. That's our first answer to this new evidence issue. And our second answer is that it isn't very surprising that the Court of Appeal did not suggest that the new evidence of itself meant that the judgment could not stand. The fresh evidence concerned the investigation in China of the allegations of torture, as I've shown the court. But the judge decided, by reference to facts which are not in dispute, the judge decided that there was no bribe whether or not there had been torture. So the new evidence, which goes to the question of whether there was torture, cannot be a basis for sending the case back if the trial judge was entitled to find, as we say he was, but there was no bribe whether or not there was torture. In any event, if my friends were to succeed only on the basis of the fresh evidence, it would be appropriate to remit the case to Mr. Justice Knowles, not to a new judge, but that's a very minor point. So for all those reasons, we respectfully submit that the Court of Appeal was wrong. It was wrong to conclude that the trial judge had found no torture, and the Court of Appeal was wrong to criticise the trial judge for making a finding of no bribery, irrespective of whether there was torture. There was no defect in the reasoning of the judge. He took account of all relevant factors, and my friend's case, powerfully presented, of course, the written case, and accepted by the Court of Appeal, amounts in substance to an impermissible attempt to invite an appeal court to revisit findings made by the trial judge, indeed findings of fact, which are not in dispute. That's my case on the first issue. My Lord Burrows has a question for you.
Yes, can I ask you this question, Lord Panic? In a situation where one has as centrally important an admission allegedly obtained by torture, I think the Court of Appeal indicated that the correct approach would be one where one first decides whether that admission or admissions are admissible. In other words, one makes a view or takes a view on the impact of the torture. And then, if one decides it's admissible, one might go on to decide its weight. Were they not saying correctly of Mr. Justice Knowles that he didn't take that most straightforward approach?
Well, your Lordship is perfectly correct that Mr. Justice Knowles did not take that approach. The question is whether, as a matter of law, Mr. Justice Knowles was obliged to take that approach. And my submission is that there is no obligation on the judge to decide first or at all whether the hearsay evidence was obtained by torture in circumstances where the judge is satisfied on all the evidence that there was no bribe, by reference in part to the fact of the admissions, taking them at their highest, and even assuming that there was no torture. The judge is perfectly entitled to do that. I mean, to determine as a matter of fact, were these admissions obtained by torture is a very difficult exercise, as the judge indicated. And where this judge, in the particular circumstances of this case, feels able to decide the real issue in the case, bribery or no bribery, I say, for all the reasons I've given, he is not obliged to determine an incidental question unless he feels, and he did not, that he cannot determine the central issue, bribe or no bribe, without determining the question of torture. His approach was that there were very strong reasons for thinking no bribe, and for thinking that even though these admissions had been made, whether or not there was torture. My Lord Leggett had a question more.
It is, isn't it, clearly implicit in the judge's approach that he treated the confessions as admissible and found that nevertheless he was not persuaded that there was bribery.
Well, he certainly was persuaded that there was not bribery. I wouldn't go so far as to accept that he treated the admissions as admissible. I would prefer to put it on the basis that he treated the admissions as admissible de bene esse. He was prepared to proceed on that basis and find that taking the admissions at their highest, they still, for the reasons he gave, did not provide a basis for outweighing, in his judgment, all of the reasons he regarded as strong reasons for thinking there was no bribe.
Well, put it another way, though, did not find on the balance of probability that there was torture, and it follows from that, doesn't it, that the confessions were admissible or had to be treated as admissible in the absence of a finding that justified excluding them.
Well, the judge proceeded on the basis that he wasn't making a finding torture or no torture, but he did, in practice, he did treat the admissions by reference to their content. He didn't dismiss the admissions. He treated the admissions as having been made, and he treated them as something, hearsay evidence, that he should weigh in the balance when he asked himself, do I accept that there was a bribe? And he gave various reasons for not being persuaded by the confessions, even though he wasn't saying that they were the product of torture. He noted, as the court has seen, that they were first made without any lawyer present. He noted that he, the judge, had many contextual bits of evidence that the Chinese court did not have, and he explained why it was quite possible, quite credible, that these individuals should have made confessions even if they were innocent of the offence. So that's my answer to my lord.
Lord Panek.
Yes, my lord.
So just on that point, in terms of approach, your own submissions at the trial were to take the confessions at face value and say no bribe. And the torture allegation came, I think, third in your sequence of submissions.
Yes.
But also in relation to paragraph 90, which is the circumstances of questioning and the criticism that by taking that into account, the judge was relying on the possibility of torture. Now, you said the Court of Appeal made this criticism. It's not an important one. You didn't actually say whether you disagree with the criticism, and if so, why?
Oh, well, in any event, we do disagree. I'm grateful to my lord. We do disagree with the criticism for this reasoning, that questioning of the PSB officers may have been of assistance to the trial judge for reasons other than identifying whether there had been torture. It would be relevant, the questioning of the PSB officers, to assess whether, and if so, to what extent, the admissions were induced by the prospect of a lenient sentence. That would be another reason for questioning the PSB officers. For example, if one had them in the witness box, on behalf of Shagang, I would have wanted to ask them how often they had referred in questioning to the prospect of a lenient sentence if admissions were made, in what terms had they referred to leniency, had they referred to their knowledge of whether a defendant pleading not guilty was likely to be acquitted, matters of that sort, which are not relevant to torture, but they're highly relevant to what weight one should give to the admissions that were made. So I don't accept the substance of that criticism, but in any event, as I've indicated, the Court of Appeal said that this wasn't a major plank of their criticism of the trial judge.
But may there not be circumstances relevant to the voluntariness of a confession that fall short of torture that you might want to explore had there been the possibility of doing so?
Well, I'm grateful. Yes, just the feeling on the defendant, on the person being investigated, of pressure, various forms of pressure that may not amount to torture as defined in international instruments, but may be very relevant to the weight which the trial judge would give to the confessions as hearsay evidence. I'm grateful to Your Lordship. Yes, I would respectfully agree.
I think the matter perhaps that might be explored is whether there was actually any evidence of bribery that was put to the individuals, or whether it was said that they just came out with these confessions of their own, entirely of their own initiative and volition, without being confronted with any evidence of guilt.
Yes, I respectfully agree. There's no evidence of that, as far as I'm aware. I'll be corrected if I'm wrong, but there's no evidence of that. Yes, my Lord.
Can I just take you back to my Lord Legate's point?
Yes.
Because you seemed, as I understood it, reluctant to accept that the judge had effectively treated the admissions as admissible. And I'm just slightly puzzled by that. I can see entirely your submission that he decided the issue of bribery or no bribery for reasons that had nothing to do with whether there was torture or no torture. I understand that.
Yes.
But he did put forward reasons why he would be not willing to place, on the face of it, much weight on the confessions. Now, that seems to me that what he must therefore have been doing is saying the admissions are admissible, but for these reasons, one hesitates to place too much weight on them. And I'm just struggling as to why you don't think that that is a correct way of seeing it.
I take your Lordship's point that as a matter of logic, you can only look at the weight of the admissions as hearsay evidence if they have been found to be admissible. I take your Lordship's point. I think that's the point your Lordship is putting to me. My analysis that I'm presenting to your Lordships of the reasoning of the judge is that he was not deciding the first question, were these confessions produced by reason of torture, in which case they were inadmissible. He's saying, I don't need to decide that. He is moving on to say, even assuming that the confessions were not the result of torture, it is a question of what weight I give to the admissions. And his Lordship's approach that I won't decide torture or no torture should not lead me, the trial judge, to ignore the admissions. I have to confront them. I have to address them. And therefore, in my submission, perfectly permissibly, and indeed to the benefit of HNA, he treats the admissions as hearsay evidence, which is before the court. And he then explains why he does not think that that hearsay evidence is sufficient to outweigh the very strong reasons, as he saw them, for concluding there's no bribe. Now, your Lordship also asked me, why am I resisting the conclusion that the judge must have found that these admissions are admissible? And the reason why I'm resisting that inference is because, as your Lordship knows, I'm coming on to the second part of the case. And if I fail on the first issue, and the case goes back to a trial judge, we want to be able to argue both that these admissions were the result of torture, in which case they are inadmissible, or in the alternative, even if they are admissible, the risk that they were produced by torture is something the judge must take into account when deciding on the weight to give to the admissions. That's why I'm making a point of this.
Yes, Lord Panic, writing succinct judgments is generally regarded as a virtue, but this whole point might have been avoided if the learned judge had said, "I'm making this point de bene esse," which he didn't in terms, but you say it is to be implied.
Well, I'm saying that, my lord, for all the reasons I've given. Of course, what one can often say as an appellate court, this could have been done better. It could have been better expressed. It could have been more fully expressed. And I'm not seeking to defend this judgment as a perfect example of the way in which a trial judge should express his or her reasoning. But that's not the issue. The issue is whether it demonstrates, as the Court of Appeal identified, an error of law in the sense that there is a defect in reasoning, which means that the judgment cannot stand. And for the reasons I've sought to explain in my submissions and in my answers to the helpful questions that your lordships have put to me, that is my case on issue number one.
Thank you.
Can I then turn to the second issue in this appeal? And as I identified, this arises if your lordships are against us on the earlier material, and if this court agrees with the Court of Appeal that this matter must be remitted for a further hearing. The second main issue on this appeal is whether, and if so, to what extent, the allegation of torture remains open for assessment on such a retrial. The Court of Appeal's conclusion was that the new judge should consider whether there was a bribe on the basis that there was no torture leading up to the admissions. I can show your lordships where the Court of Appeal so found. It's at MS 206, paragraph 88. Paragraph 88 on MS 206, the Court of Appeal says this: "We will therefore allow the appeal and send the matter back for reconsideration of the issue of the weight to be attached to the admissions and of the issue of bribery in the light of this judgment, and on the basis that the issue of torture has already been decided." Then they say no need for a full retrial. And they return to the point at paragraph 91, where they say, "After we provided the parties with a draft of this judgment, Shagang put in written submissions contending there was an obvious error in paragraph 60, which I'd read earlier. Our judgment stated that Mr. Justice Knowles had been unable to find on the balance of probabilities that the admissions had been obtained by torture. When Shagang submitted, he actually made no finding as to whether or not on the balance of probabilities the admissions had been obtained by torture. Accordingly, Shagang asked that we should remit the question of torture to the judge, rehearing the matter. In our judgment, Shagang misunderstands our decision. We have determined that the judge ought to have decided the question of torture before he decided the question of bribery. As we say above, he did not. He may have avoided deciding the question of torture, partly for the inappropriate reasons he gave in paragraph 105, that's that there needed to be more investigation in China. But his judgment made clear that whilst he could not rule out torture, he had not found it proved on the evidence. Had he found it proved on the evidence, he wouldn't have used the language he did. We have held that the consequence of his approach as a matter of law was that he'd not found torture proved. Shagang is seeking an inappropriate second bite of the cherry when it did not appeal the refusal to find torture. In these circumstances, the case will be remitted to another commercial court judge for reconsideration of the weight to be attached to the admissions and of the issue of bribery. So that's what they held. Our submission is that the Court of Appeal was wrong on this respect. It must be for the trial judge to consider all the evidence and to decide two things. First of all, whether there was torture, in which case the admissions are inadmissible, or if the judge does not so conclude, the judge must take account of the risk, if any, that there was torture in deciding what weight to give to the admissions. Now, our submission is that the Court of Appeal were wrong in their approach for two reasons. And the first of them I've dealt with already. The first argument I advance is that the Court of Appeal was simply wrong to conclude that Mr. Justice Knowles had rejected the allegation of torture. I've made my point on that. He hadn't decided the question. He said it wasn't necessary for him to do so. And I've addressed that point already. It's relevant to this part of the case too, but I won't repeat. I won't tire the court by repeating what I've already said. Just make one further point under this head. The court may think that if the Court of Appeal's criticisms of Mr. Justice Knowles's judgment do have force, that is, there were serious defects in the reasoning process that he adopted, and he should have determined torture first, and he didn't, it is inconsistent then for the Court of Appeal also to say that the deficient decision of Mr. Justice Knowles on torture, because it would be a deficient decision on this premise, must stand for the purpose of what happens on the retrial. That can't, in my submission, be right. If the judge failed properly to decide this case, then the new judge must be allowed to do what Mr. Justice Knowles failed to do on this premise and make proper findings on the serious allegations of whether the admissions evidence was admissible. That's the first point I want to make. But in any event, the Court of Appeal was wrong to exclude consideration of torture at a retrial, because the new judge, even if he were coming to this afresh, and even if he's not coming to this afresh, has two tasks in relation to an allegation of torture. The first of them is to decide whether or not the admissions evidence is admissible, which depends on whether torture is found, yes or no. But the judge has another function, also very important, in a case where there is no finding that torture has in fact occurred on a balance of probabilities. And that is to take into account the risk, if any, that the admissions were secured by torture in assessing the weight to be given to the admissions as hearsay evidence. That, in my submission, is not a binary question of whether torture did or did not occur. It's not a binary question for two reasons. First, because the admissions are hearsay evidence, and I'll come to that. And second, and in any event, because in the context of allegations of torture, the appellate committee decision in the case of A number 2, which I'll come to, requires that the risk that evidence has been obtained by torture must be taken into account in assessing the weight to be given to it. And all of this applies even if the premise of my Lord Borough's question to me is correct, that this judge found that there was no torture on a balance of probabilities. He still has to consider the risk of torture in deciding the weight to be given to the hearsay evidence in the admissions. So that's the submission. Can I develop that? First then, and I imagine I can take this very speedily as to the background material, background legal material, that is the proper approach to the weighing of hearsay evidence. There's no dispute. Yes, my lord.
Although you're dealing with it as hearsay evidence, and it obviously was, the point you make doesn't depend on evidence, does it? It will be equally relevant to the weight of any evidence given, live evidence, to take account of possibilities such as that it may have been induced by torture or threats or promises or anything of that sort. It's always relevant in considering reliability and weight, hearsay or not.
I accept that point. The point has more force, I would suggest, in relation to hearsay evidence, because of course the court doesn't have the advantage, normally the advantage, not always, the advantage of hearing the individual give evidence, seeing them cross-examined. But of course I accept what your lordship says, we also have the benefit that Parliament has expressly set out in relation to hearsay evidence, how one proceeds. But I do take your lordship's point.
Yes, but you are founding, I think, on the terms of Section 4 as well.
Well, I am, Lord, yes, I am. And I'm relying also, whether it's hearsay evidence or not, I'm relying on the important guidance that the appellate committee gave that is specifically directed to evidence, hearsay or not, evidence which is said to have been produced by torture. Now, there's no dispute between the parties on the general principles, that is that the admissions evidence, primarily because it's hearsay, but not exclusively, must be assessed by the judge as to its weight by taking into account questions of torture. And the HNA's written case accepts this at MS 151. Paragraph 83. MS 151, paragraph 83. This is my friend's written case, where they say it's common ground a judge evaluating a hearsay statement must do so by reference to Section 4 of the Civil Evidence Act, taking into account any circumstantial factors relevant to reliability in assessing the weight to be given to such a statement. It is common ground this involves an exercise of judgment. It's common ground that questions of weight do not permit a binary answer. For the purposes of this appeal, HNA takes no issue with the principles and analysis set out in our written case, and indeed in Liberty's submissions. And they make clear, HNA, at paragraph 84, the next paragraph, that they are taking their stand on this not being what they describe as an ordinary case. And I'll deal with that argument in a moment. So there's no dispute on the general principles, and there is a helpful summary. Your lordships may not need it, but there's a helpful summary of the history of legal regulation of hearsay evidence in the written case for Liberty at paragraphs 9 to 13, MS 174. Now, the language of section 4 is illuminating. My Lord the Deputy President mentioned it, and so I should go to it. Authorities, volume 1, MS 1328 is the Civil Evidence Act 1995, dealing with the admissibility of hearsay evidence. Section 1.1, evidence is not excluded because it's hearsay, and 1.2 on MS 1328 defines what hearsay evidence is. And as my Lord the Deputy President mentioned, section 4, considerations relevant to the weighing of hearsay evidence, and we're told at subsection 1, in estimating, and we emphasize that word, in estimating the weight, and we emphasize that word, if any, to be given to hearsay evidence in civil proceedings, the court shall have regard to any circumstances from which any inference can reasonably be drawn as to the reliability, we emphasize that word, of or otherwise of the evidence. So no question that the court in this context, and there may well be many other contexts where the court considers evidence, but certainly in this context, that is hearsay evidence being assessed, the court is not making binary findings on whether a collateral matter such as was there torture is true or false. That is the approach of the courts in deciding admissibility, but in deciding weight, it's not a binary question. The court considers all relevant circumstances. Now, the argument for my friends, as I indicated, is not to challenge any of that, at least not directly, but to submit that this is not a, quote, ordinary case. And can we go back to why they say that at MS 152 in their printed case? And at paragraph 84 on MS 152, my friends tell the court that this is not an ordinary case because, and it's the third line, the existence or non-existence of a state of affairs that might affect its reliability has, their emphasis, already been the subject of a binary determination by him, that's the judge, at an earlier stage in the proceedings. So the argument against us, as I understand it, is that the true interpretation of the judgment of Mr. Justice Knowles is that he had determined that there was no torture, in the sense that he was not satisfied on a balance of probabilities that there was torture. And my friends argue that once the judge had made that determination, that also determines any question of weight to be attributed to the admissions when we get to the stage of assessing all the evidence. And in my submission, that is fundamentally wrong, not just for the reasons I gave earlier. The judge made no such finding, and even if he did, the premise of this second issue is that, with great respect, he made such a mess of it. It's inconsistent with that to say his findings must nevertheless bind the new judge. I've made those points. But the argument is also fundamentally wrong, because taking it at its highest, all that Mr. Justice Knowles decided was that he was not satisfied on the balance of probabilities that there was torture. But that, even if he did so find, that does not determine more than that this admission evidence is admissible. The question remains, what weight should I, the judge, give to this admissions evidence? And any finding that the judge made does not rule out there being risks, perhaps serious risks, that this admissions evidence was the result of torture. Maybe a 30% risk, maybe a 40% risk, maybe a 49% risk. And indeed, that was what the judge actually found, because if one goes back to paragraphs 101 and 104, it's very clear indeed in my submission that this judge was seriously troubled by whether these admissions were the result of torture. So I say that even taking the criticisms of Mr. Justice Knowles' approach at their highest, the issue remains, what weight should the new judge give to the admissions evidence? And the new judge is obliged by Section 4 of the Civil Evidence Act to ask himself or herself the question, what risk is there that this evidence was produced by torture? And in the light of that, what weight shall I give to that admissions evidence? Now, the Court of Appeal relied, and my friends relied, for their approach to this question. They rely on a Court of Appeal, they rely on an appellate committee judgment in the childcare context of Re B, and that appears at Authorities Volume 1, Tab 3, MS 1424. And before we look at that case and the speeches in that case, I should just emphasize that it was not a case about hearsay evidence. It's not a case about the weighing of hearsay evidence. The speeches in my submission tell this court nothing about the proper approach to hearsay evidence. And indeed, hearsay evidence and Section 4 were not mentioned in the speeches of the appellate committee. This was a case, just to summarize it, in which there was conflicting evidence from a man and his stepdaughter as to whether he had sexually abused her. And Liberty's written case in the present proceedings explains, it's MS 178 footnote 11, that the first instance judgment records that both the man and his stepdaughter had given oral evidence in that case, Read B. And the judge, Mr. Justice Charles, had not been able to conclude on the balance of probabilities that either of them, that is the stepfather and the stepdaughter, was telling the truth. The judge said he couldn't decide, and the appellate committee was very critical of him for that failure. The speech of Baroness Hale for the appellate committee, there was also a speech of Lord Hoffman's, which I'll come for the appellate committee as well. The speech of Baroness Hale deals with this at page 24 of the report, MS 1437. At MS 1437, paragraph 30, Her Ladyship says, however, despite an elaborate and meticulous analysis of all the evidence, the judge was unable to make a finding about the alleged sexual abuse of the child by the man. And Baroness Hale was very critical of the judge at paragraph 31. If the judiciary in this country regularly found themselves in this state of mind, our civil and family justice systems would rapidly grind to a halt. And there's some detail about that. And Baroness Hale explained how unsatisfactory this was. And I'll come back to paragraph 32 in a moment. The issue in the case is identified by Baroness Hale at paragraphs 22 to 24, MS 1435. And at paragraph 22, Her Ladyship sets out at letter F at section 31, subsection 2 of the Children Act 1989, which will be very familiar to the court. A court may only make a care order or a supervision order if it's satisfied that the child concerned is suffering or is likely to suffer significant harm, and B, that the harm or likelihood of harm is attributable to the care given to the child or likely to be given to him if the order were not made, not being what it would be reasonable to expect a parent to give to him, or the child's being beyond parental control. And Her Ladyship explains this case is about the meaning of the words is likely to suffer significant harm. How is the court to be satisfied of such a likelihood? This is a prediction from existing facts, often from a multitude of such facts about what has happened in the past, the characters, the personalities, the things they've said and done. Do those facts have to be proved in the usual way on the balance of probabilities, or is it sufficient that there is a real possibility that they took place, even if the judge is unable to say it's more likely than not that they did? That issue was authoritatively determined in favour of the former, that is findings of fact, by a majority of this House in Re H. It was reaffirmed in two later decisions, and Her Ladyship sets them out. And at paragraph 24, Her Ladyship says, in this case, the children's guardian, with the support of the local authority and the mother, seek to overturn the earlier decision in Re H and the other cases in favour of a real possibility test. So that was the issue in those proceedings, and the answer given by Lady Hale for the appellate committee is at MS 1443, paragraph 54, where her ladyship says that she would unhesitatingly decline the invitation to overrule the earlier cases. She says the reasons given by Lord Nichols, who gave the speech in Re-H, for adopting the approach which he did remain thoroughly convincing. The threshold is there to protect both the children and their parents from unjustified intervention in their lives. It would provide no protection at all if it could be established on the basis of unsubstantiated suspicions, that is, where a judge cannot say that there's no real possibility abuse took place, so concludes there is a real possibility it did. In other words, the alleged perpetrator would have to prove that it did not. Mr. Cobb accepts must be proved on the balance of probabilities that a child is suffering significant harm, but he argues those same allegations, which could not be proved for that purpose, could be the basis of a finding of likelihood of future harm. If that was so, there would be no need for the first limb of the section at all. Parliament must be presumed to have asserted it for a purpose, etc., etc. So the reasoning of Lady Hale for the appellate committee was heavily influenced by the statutory context in which the issue arose, and this court can see the good sense of the judgment that was made. I then need to deal with the passages that are relied upon, which I say are taken out of context by my friends, relied upon to suggest that in the context of a case such as this, the finding, if finding it be, that there was no torture, excludes consideration of risk of torture. I noticed the time. Would that be a convenient moment for the court? Because I'm making, in terms of the material I need to address, good progress in my submissions.
Yes, I think, Lord Panic, you have until 3:30. You're comfortable that you'll finish in good time?
Oh, yes.
Yes. Well, then the court will now adjourn and resume at 2 o'clock.
Thank you very much.